6 years ago, this wasn't really a thing in the landman orbit. We all got very busy for a period of time with capturing rights and putting these projects together. So there's a lot going on with what are the rules of the game?
Primacy, of course, is eventually the appropriate state organization will administer the EPA's rules for Class 6 wells, which is what a carbon capture, carbon storage well is.
The EPA guidelines, they're setting what they believe is the correct measure for sort of technical concerns as well as administrative. So that they're going to make sure that the parties that are applying for these permits are fully suited for the work that they're going to do. So there's a lot of hurdles that you have to achieve just to make sure that you are able to carry a project forward.
Land insights, market trends, industry experts. Welcome to the Land Department Podcast, the state of land and energy as we see it.
All right, it's been a while since we've discussed CCS.
It's time for an update. We got a lot going on here.
Yeah. And new guests for the show, right?
Yeah, we do. We got Casey McAdams and Jerry Walrath. Jerry and I have known each other for a number of years here in Houston. Our groups have worked together a number of different times. And like how most of our guests end up on the show, I see that they're discussing something or they publish an article and I was like, man, we need an update. So I cornered Jerry one time at a landman function and asked him if he would mind coming on. And he was gracious enough to join us. So appreciate it, Jerry. Thank you very much.
Happy to be here.
Awesome.
Yeah.
And so I hadn't had a chance to meet Casey before or work with Casey very much, but as Jerry alluded to earlier, he's the expert. He's the man behind the scenes that really knows everything. And so Casey, I'm super excited to have you on as well.
Yeah,
and,
thanks a lot for having me.
Yeah. Just really wanted to kind of dive into the latest and greatest of where we stand in the whole carbon capture and sequestration business, right? 6 years ago, this wasn't really a thing in the landman, orbit. But boy, we all got very busy for a period of time with, capturing rights and putting these projects together. And then it's kind of just, I don't want to say stalled, but now the waiting game starts. And then all the work in the back, kind of the background is happening. And so there's a lot going on with what are the rules of the game? Where do we stand on primacy? Where do we stand on unitization? Who owns the pore space? Like all these things have kind of always been up in the air and it's a long process. So wanted to have the guys on to really just kind of give an update on those things. So gosh, maybe what do you think's the best? Why don't we just dive into primacy? I mean, that's kind of been from the get-go, primacy was the thing. And, all knowing that from a federal standpoint, primacy, we don't want that. It'd take forever to get these permits issued. So the goal has been to get primacy at the state level. And where do we stand today, guys? We can start with Texas, we can start with other states, but what's the latest?
Well, I'll jump in for Texas, and then so it looks like I know something, and then Casey will jump in and flesh it out. And the short answer to this is that on April 29th, the EPA and the Texas Railroad Commission signed a memorandum of agreement and that kind of lays out what the basic turnover will be on primacy. And primacy, of course, is eventually the appropriate state organization will administer the EPA's rules for Class 6 wells, which is what a carbon capture, carbon storage well is. And the memorandum of agreement is not a final grant of authority, but it does delineate it. It's more like an 11-page document that it just kind of sets out what the general, okay, this is happening, what the turnover will be. Is it going to be pending cases? The answer is yes. And how will that, it indicates both the willingness of the RC to accept the responsibility and the EPA to let the RC accept the responsibility. The reason that it's far preferable for the state agency to administer the rules is that the RSC is very, very deep in Texas geology and geophysics, and knows literally the lay of the land, as far as the avenues and topography that's going to be used for underground storage. So it's when any state gains primacy, it's a sigh of relief on everyone's part, because the state agency that's been responsible for administering the rules for the development of oil and gas is now going to, and has this huge store of knowledge, is now going to go ahead and administer the rules for carbon capture, which is something of an inverse process to oil and
Yeah.
gas development.
Yeah. Yeah. So what's the timeline typically look like? You mentioned you got the letter of understanding or whatever you referred to it as. From that point, when can we expect, or when's a reasonable expectation of when that actually is formalized?
I think the best guideline was probably how long it took some other states, and that's I'm gonna look to KC for that.
Yeah, so thanks, Jerry, for handing that over. And that's really good explanation as far as dividing it out between sort of the federal with the EPA and going to the state, like the Railroad Commission with Texas. Before states apply, and then to answer your specific question as far as timeline, it can vary. It can take several years. Texas has actually been working this for as long as some of the other states that have applied and have achieved primacy, Wyoming and North Dakota being the first, then Louisiana followed with that, and then West Virginia just at the beginning of this year. So I think a lot of that has been timed on the discussions with the state agencies and how quickly they're willing to advance it. Seems that Texas has moved kind of in fits and starts, whereas in some of the other locations, it was a smooth, fairly year and a half to 2 year process, I believe, for like Wyoming and North Dakota. Louisiana took a little bit longer, but they had also delayed in their application. A lot of the timing has to do with understanding EPA rules because they're sort of the basis for it. And as the states are taking on the responsibility and achieving primacy, they are having to reassure that the standards that there's a clear understanding of what the existing EPA standards are so that there's a base minimum set for whatever state is going to put in place as their regulations. But then the greater efficiency is what Jerry referred to is each of the state knows their own constituency. They know the land, they know the geology, they know the actors that are involved and all the stakeholders. So they have a better idea of what they need to address on a local level. And Texas being such a large state, having such a long history of oil and gas production, it's a lot bigger and there's a lot more stakeholders involved and there's a lot more to go through. So that's probably a good indication as to why it's taking longer. So there is no strict timeline, but it, usually once all the stakeholders are lined up, it can be a fairly quick process.
Okay. So primacy at its core and its most basic definition is handing over rights to a given state to administer the regulations of the EPA. But you mentioned, each state is obviously best suited to do that with respect to what's important to the state and the scenario circumstances with the given state. So you've got a baseline set of rules that the EPA sets, right? That's going to be universal for everywhere. What types of things kind of go above and beyond that a state may want to implement, or does it work that way? In other words, when you get primacy, are you establishing, all right, yes, we understand what is required of us as a state to administer the EPA's rules, but does the state get to add things to that or on top of that are specific to their state? Is that part of the process?
Yeah, so you hit the nail right on the head. With the EPA guidelines, they're setting what they believe is the correct measure for sort of technical, safety, and environmental concerns that you'll have to, and then as well as administrative, sorry. So that they're going to make sure that, the parties that are applying for these permits are fully suited for the work that they're going to do. They're going to make sure that they can operate in a safe manner, and safe being health of the people, the environment, and of the projects, right? There's a large technical review and going through the permitting process. So they want to make sure that the groups are technically savvy and know what they're doing. So there's a lot of hurdles that you have to achieve just to make sure that you're able to carry a project forward. But in the individual states, you have different concerns. Wyoming may have more of a particular mining coal focus where there's things that were developed in their state. I've been working a lot of projects in Louisiana where coastal wetlands are a serious issue. So, for Wyoming, it's not going to be as big a deal with the coastal wetlands, whereas Louisiana, you're going to have a very intensive focus on it because that's a very significant issue for Louisiana. So
Yeah. So I guess where we stand now in Texas, kind of bring it back to you, Jerry, is we're in that process of Texas and the EPA getting on the same page, make sure that all the ideas and things that are important to the state of Texas are aligned with what the EPA requires and expects of the state to be able to administer the program.
Yes, that's correct. I mean, Texas has made its representation that it can administer the EPA rules, and the EPA has accepted that. So
Yeah.
it's a question
we're
of
just-
moving forward from there. There are, of course, other pieces to the Texas emergence as a
Sure.
CCS power, but
Sure.
that's fairly key.
Sure. And so you mentioned obviously the Railroad Commission is going to be responsible for this. What indications are we seeing? Is this do we feel like this is going to be a big enough thing to have kind of a dedicated CCS group within the Railroad Commission, or are they going to administer this through their normal oil and gas division? Have you heard anything to that point? Either one of you guys?
I have not heard anything. It would the RSC does a great job. Sometimes they are a bit thinly staffed. I imagine it's a continuous process as far as determining the allocation of work for existing staff. And it's the volume of CCS is probably not going to be high enough, for instance, to have a dedicated hearings examiner for it
Yeah.
or something like that. But they may choose to place the CCS caseload in the hands of certain individuals just to leverage that expertise.
Okay. Casey, you mentioned you were active in Louisiana. A lot of landmen are busy and have been quite busy in Louisiana working on these projects. I mean, it's obviously when you talk about refining areas, that's where these CCS injection projects they're prime for it. What's kind of the state of primacy in Louisiana? Obviously, it's been issued, but what things maybe did Louisiana do? You mentioned wetlands. Are there other things that are really unique that you're seeing and you guys are experiencing that are maybe challenging from a permitting standpoint in Louisiana?
Well, there's a lot to unpack in all of that, but yeah. So Louisiana,
We can keep it friendly,
No, it's great pointed discussion. So just really pulling back into what we were just talking about, achieving primacy. Part of the handover involved was reassuring on all sides that there was the technical capabilities and there was the administrative capabilities to take all these on. Part of the relief from the EPA standpoint is that they were all of a sudden flooded with 10 times the number of applications that they had or indication towards applications in the space of about 18 months as they had in the past 30 or 40 years. So in Louisiana, there was a shift as far as internally administratively to make sure that they had the right people on board, that everyone was up to date and focused on that. So, there's both internally and externally, then for the landman, there's been a large focus on, what are the sort of technical things that we need to know about here? How are the leases going to comply with whatever the state's doing? In Louisiana in particular, you've got a long history of oil and gas development for both the good and the bad, right? There's been historic issues that now Louisiana is very keen to address, as well as I think most of the folks in the industry are, because in order to continue operating, you need to be a responsible operator. So, for instance, a lot of the focus around decommissioning and returning sites to their previous condition has been a big issue, and that's particularly challenging in southern Louisiana when you get into a lot of the coastal zones, and there's a lot of other mixed use on land now. Not just what we're seeing as landman from renewables and solar pipeline and some of these other items, but there's also a large, agricultural, there is hunting and fishing, there is all sorts of
Commercial
other,
fisheries. Yeah.
there's all sorts of other uses there, which, tie into development there that are particular to Louisiana, which you really need to be sophisticated in the local knowledge to know. It's not that people can't learn it, but that it's very complex, and there's a lot of issues in Louisiana that may not rear its head elsewhere. And, what might happen in the Texas Gulf Coast is maybe in some ways more similar to Louisiana than what happens out in the Permian. But it's, that's why being a landman, knowing the location specific knowledge is really key.
Yeah. You mentioned West Virginia. As far as from our company's standpoint, most of our CCS work over the last several years has been obviously along the Gulf Coast, some upper Midwest around the ethanol, plants and things up there. We did some spot projects there, but we haven't done much in West Virginia, and obviously that's coal country. It was interesting to hear that West Virginia got primacy very quickly. What's the volume of projects look like there in West Virginia from a CCS standpoint? Were they just trying to get ahead of it to encourage, injection projects there? What was behind that? Do you have any knowledge to that?
Yeah, so as a landman, I did work Appalachia for a number of years between 2013 to 2016, but I really don't have a ton of particular knowledge as far as the CCS. I will say that the portion, so CCS covers a wide umbrella of things from EOR to carbon storage and sequestration purely, also then to the DAC, the direct air capture, right? And there's a lot of different niches within that. The particular focus of mine is working with hard to abate industries. So your power producers, your petrochemical plants, your industrial sites, cement, right? Well, with coal being a big factor up in West Virginia, I would expect that they're hoping to bring industry in that area and that can kind of dovetail and build on to existing infrastructure. A lot of the projects that I am familiar with along the Gulf Coast are doing particularly that. They're looking at CCS as an additive to strengthen and sort of future-proof their industrial base. And so it's those industries coordinating with the capture companies, and then you have your transportation and storage to get the entire project done. So again, I really don't know in particular why West Virginia was so driven to do that, other than, speculating that it's similar to what Louisiana and Texas is doing there.
Yeah.
They're locating what they have and what they can use and finding a way to make it work.
Yeah. Well, good. It makes me feel better because I've heard that. And I was like, what's that all about? Am I missing something here? I mean, as landmen, we've been very busy in that part of the world as well. And I guess North Dakota and South Dakota kind of tend to fall in that same rationale, or is there something of interest up there going on that?
Well, so I know with North Dakota, there's also the large agriculture, and they're producing a lot of biofuels. So there's a lot of potential for that. So they've already announced and permitted some pretty big projects up there. So The main thing is right now, as far as my focus of what it is, you need an emissions rich area with the right geology and significant enough land portions or land sizes where you can do these projects, because they do take large contiguous areas. But then you also need the infrastructure in terms of the people in place who have the technical
The skill
savvy to do the
set.
work. Yeah.
Yeah. Yeah.
And the industry backbone, as well as the government, who can make sure that they can administer it and
Administer it.
oversee it.
That
So it
makes
takes a
perfect
lot of
sense.
working parts to put all those together, and I think that's kind of how you're seeing the landscape evolve.
Yeah. So you mentioned the key thing that's big for landmen is kind of the rationale behind big ranches. That's what big properties are very appealing to putting these projects together, at least in the early days.
Yeah,
Um,
absolutely.
Jared, give the rundown on why was important, and kind of as landmen, why, we encouraged, our clients and our companies to go that route
Sure. I
with
mean,
developing these projects.
yes, because I mean, the basic thing is in Texas, there's been some movement on ownership of pore space. There's been, uh, which I'll discuss in a minute, but in we have nothing in place for unitization. So, if you want to do a carbon capture project, what you need is you need a somebody who owns it fee, surface and mineral. So, because we still don't know who we're offending, and it needs to be a large property, because the potential tort in all this is if one of the damages, if the plume escapes the property boundaries. Is it a coastal versus Garza situation? Is it a loss of use? What is it? What rather undefined. But the biggest thing is the ownership of pore space, and we've had we had some movement last legislative session. We had two companion bills. Senate Bill 1258 and also House Bill 2762. And the focus of both those bills was to get the ownership fixed.
Yeah.
So
Or
we could say,
defined.
okay,
What are the
pore
rules of the
space is
game
owned
here? Yeah.
by, and the unfortunately the both those bills died in their separate committees. The House bill died in energy resources, and the Senate bill died in natural resources. And I mean, as you know, there are many bills that are introduced during the legislative session, and there has to be a certain energy around them to get
Push them through.
forward. Yes,
Yeah.
exactly. And also, one of the co-sponsors of the Senate bill was had another big bill, and her focus largely, which did get passed, and her focus was largely on that, and this got sidelined a bit, just as a structural matter. The We did also have some movement with the Texas Supreme Court, which was fairly significant but not definitive, and I'm going to take you through that very briefly. The case is called Myers Woodward LLC versus Underground Services Markin LLC, and essentially this is a salt case. This is a hard minerals case, but what it has to do with is who owns the space once the salt is mined. And this was not development under a lease. This was actually conveyance of the minerals in 1947 to a predecessor of underground services. And once they exhausted the salt and mined it, and I should point out that is actually kind of, we have salt clients, and that's a fairly normal arrangement, that over time they buy the mineral rights for the hard minerals and then mine it, rather than doing it under a lease. Sometimes they do it under a lease, but especially as these are older transactions, they tended to buy it. It's
Buy
just
it.
easier.
Yeah.
Um,
Yeah.
and so The question is, what once it's gone, who owns what? What can you use that? Who can use that cavern for something useful? Um, and they asserted the rights to do so. USM did, and obviously the surface owner opposed that. And the upshot was the court said no, that's the surface owners to do with what as they please, because as you know, when you own land, it's from the basement of the earth up to the top of the sky, subject to the rights of others, either what's been conveyed or reserved, or in the case of the sky, sometimes by regulation. And the court came down on the side of the surface owner, and a lot of some people have taken this as an absolute. The pore space is owned by the surface owner, and the problem with that analysis, that very broad analysis, is we haven't had any subsequent decisions because this case is so new, taking it and applying it in other contexts. And it leaves open the possibility that it could be restricted to its facts, meaning a subsequent case could say the pore space that the holding is the pore space is owned by the surface owner when a hard mineral is conveyed and then extracted.
Yeah.
And they own what's left behind, not in it. Because again, with CCS, we're not simply talking about using exhausted fields, although that's a focus. I mean, in the future, it also may be geologic pore space that's been identified that has nothing to do with oil and gas.
Yeah. Yeah. So, they haven't come out and stated what they want the rules of the game to be, but that's what we should expect. Case law in various scenarios will give context clues as to how we should operate. Right.
I think there's enough money up here that somebody will eventually bring an action that's going to try and extend USM to a carbon capture context. And if we don't get that in the next 2 years, the other thing is that this decision kind of gives a little bit of cover to a legislator who wants to introduce a bill next session.
Really get behind it.
Yes, because they can say it's no longer whole cloth. It's them saying, okay, we have some direction here from the Supreme Court, and we need to codify that and put our stamp on that. And that may be Lois Kolkhorst. He was the primary sponsor on the Senate bill, or it may be somebody else. Probably somebody in an oil and gas producing jurisdiction who is who has constituents who would benefit from being able to lease from
maybe some donors.
That's them. Donors, sure. Donor, everybody. I mean, everybody donates. Everybody donates to both sides.
That's right.
But also, I mean, if you've got somebody calling your office up and saying, "Hey, I can make a big deal here," and it's going to be great for the county, but nobody wants to put the money in until we get this nailed down, then somebody may actually take the effort to do that, especially now that they've got the cover of the Supreme Court case to do that.
That's exactly one of the biggest things that I find day to day that is consuming my time, as far as when you have a lack of regulation and you have a lot of first of kind commercial arrangements because you're joining groups together that have not been joined before into what looks kind of like a traditional oil and gas transaction.
But in reverse.
There's a lot of difficulty and uncertainty, and there's a lot of challenges around where if you're trying to put together the economics on a project, so that you can go out and hire people and move forward on it, when you don't have the regulatory regime, or when you don't have the ability to contract and do things in the way that you normally would, or you're creating the first of a kind of arrangements, you're really having to do a lot more scoping, and you're having to accept a lot more risk and variation within your economic scoping. And that really translates down into, the landman, as far as like sometimes projects seem to be moving forward and then they get stuck. And then there's the wider lens that, Jerry said, as far as industry wanting to put things in, there's a lot of work being organized to try and get those settled. So,
Yeah.
there is a lot of push in a lot of directions to try and move these forward.
Yeah, Casey, you mentioned, obviously you're active in Louisiana. Has the state of Louisiana given any clarity as far as poor state ownership or poor ownership
Yeah. So
in that state?
pore space is owned by the surface owner in Louisiana.
That's pretty clearly defined. It's not as up in the air as what we see in
Yeah.
Texas.
But you do have problems where a lot of times your pore space is going to be adjacent to traditionally producing historical oil and gas properties. So you do have to be on the safe side. You are still going to want to involve the mineral owners and make sure that you have, drill through provisions so that you're protecting your ability to go forward with the projects. And it just adds another layer of complication.
Yeah.
But
That was my next question is, in practice, what we tend to see is when you can't align your surface and mineral interests, under one ownership, you either avoid, that severed, or when you can't avoid it, you got to go in and do that kind of pass through type agreement.
yeah, so the reverse analogy I would use is in Texas, where you have the accommodation doctrine and surface use, right? A lot of times maybe your mineral owner is different from your surface owner. Well, you still have to go out and, get some sort of agreement with your surface owner, or you're not going to be able to conduct your operations. And here in Louisiana, you're going to flip that on its head, or in other jurisdictions where, the surface owner owns the pore space, but there may be oil and gas activity. You're going to want to make sure that you're covering yourself from the other angle, right?
Yeah.
So it's pretty similar, but it's just in reverse.
Yeah, but you have to, in these cases with carbon capture injection projects, you don't have that statutory accommodation there where you can say, hey, I can do this. That's not present. You have to secure agreements from that mineral estate to be able to put your project together at least from a abundance of caution standpoint.
Well, so yeah, from an abundance of caution standpoint, most of what I have dealt with in particular is going after fee owners, where it's the same, surface and mineral owner. So there's, kind of a belt and suspenders approach there where you can do it, but also those were the landowners who had the big enough contiguous pore space. So, that was where it is now. And these projects are expensive. They take a very long time to build. You're talking about, basically the same sort of cost and timeline to put together a large pipeline or an offshore platform. And that's a lot of capital for people to put up front. So the first projects that you are going to see are with the state or these large private landowners where, both the mineral and the surface is owned by the same person, and it's a large portion of land, and you can get a pretty clear contract or lease, be it with the state or with the private landowner.
Yeah. Path of least resistance, certainly.
So,
but when you have the co-development of minerals, right, that you mentioned earlier, you're having to do some sort of agreement with the leasehold owners on these large properties from an oil and gas standpoint to make sure you're clear there.
I would certainly recommend it.
Yeah.
And I would say, just as kind of a speculative matter, I mean, we do have authority in the context of oil and gas development as far as drilling through someone's horizon that you're not going to be liable to them absent damage. That's the Lightning versus Anadarko case down on the Briscoe Ranch, where they drilled through a reservoir on the way to an adjoining property, didn't produce it, and they weren't liable to the mineral owner there. So if somebody wants to be very aggressive, it would simply require bringing the case to extend that to carbon capture. But no, I mean that's kind of your point about the accommodation doctrine. That
Yeah.
we know what the deal is for oil and
Minerals
gas.
development. Yeah.
And since we're in reverse, yes, it's accommodating the mineral owner. The last thing you'd want in tort is to actually damage a reservoir and be liable for that. To impinge on somebody's right to produce their own minerals would be a problem. And those are so yes. I mean, in oil and gas development, we often secure surface use agreements that are not wholly necessary legally. They're simply,
You want to be a good neighbor.
We do it because it's better than fighting about it afterwards.
It is. It is.
Kind of the same thing.
I think so. And there's the whole argument of, you can not necessarily impede minerals development below that, but you on purpose, but by all intents and purposes, you do, because it's simply the cost of drilling through a plume, right? A CCS plume, right? That's a whole another technical probably component to that development. If say you've got an existing injection project and you're a mineral, you want to develop your mineral interest below that. The cost associated with drilling through that active injection area has to be exponential, right? If you want to keep leaks and whatever out there. Is that a consideration or something that's factored into why you want to try to align your surface and mineral interests and get joinder from your leasehold developers as well?
From a legal and business standpoint, I mean, you're going to want to look out for any potential concern. I don't think that we're far enough down the road that we really tested that out. Certainly, we'll have discussions around it, and we would sort of scenario out what possible outcomes would be and how you would handle the situation. But I personally have not had to deal with that. But certainly, if as CCS grows and you get more and more projects going, that certainly is something that's probably going to come up down the road.
Yeah. And kind of talking about the probably come up down the road, unitization. How does this work? I mean, obviously you're trying to go path of least resistance, large ranches. We've all seen that development.
Sure.
But in some instances, it's just unavoidable. You can't control a plume. And what does a plume look like? I mean, obviously you have a good feel geologically of where you think it should stop, but what do we do in the future? What are we seeing today with respect to the concept of, integrations and units and pooling of maybe adjoining smaller tracts? Jerry, do you want to unpack that a little bit?
I'll unpack that a little bit, and also you kind of alluded to some tort stuff, and I'll get into that at the end of this. The unitization. Eventually, we run out of large ranches, or eventually there's an area that's geologically perfect. It's bounded by horse blocks, whatever. We can control the plume better, and it's simply in an area where there are smaller tracts, which are going to have to be integrated, and we have no mechanism such as the P12. But again, the P12, when you go to drill your well, exists as a specific manifestation of the administrative code, and this is something that's going to have to be addressed in a future legislative session. It is a rulemaking issue. What you can, and of course, you've got the voluntary unitization. If you get the tracts under control from the surface unit, and then there's a question of, do we extend it to a MIPA-like process where we could actually fractionally integrate surface owners against their will. And I personally see that as a lot less likely because surface
big
owners
ask.
are a lot more visible than
Yeah.
mineral owners. I mean, I've been a surface owner much of my adult life. Never been a mineral owner. It seems it's rarer than you think. But it is we absolutely need it. Casey can address if what other states have done as a model briefly, and then maybe we'll shift back to the tort thing so I can answer your final implied question.
Yeah, so actually, I think North Dakota and Wyoming, the first states to achieve primacy, they followed a very similar model to what their oil and gas models were, and a lot of the Western states have now. It's the very similar process where, you're under the burden as, the person who wants to move forward with drilling the well or putting together the unit. Um, that you go out and you try and lease everyone, and you do so, and you make them reasonable offers considering the
Mhm.
market that you're in at the time that you're in. You have to present, if you can't sign up everyone that you want to include the unit in, then you need to go before the industrial commission and you make your application.
Mhm.
You go through the
Mhm.
process of presenting your evidence showing that you've made good faith efforts to lease
Yeah.
people and include them in the unit, and that it's for different states have different standards, but basically this is for the development of the common good so that there's not waste, right? Um, if you make all of those findings, then if you present all of that evidence, and then you go through your notice period where everyone has a chance to respond, put comments in, you'll go to a hearing, and then the state will decide, the regulatory body will decide if the evidence is sufficient that you have cleared the hurdle. Different states have different numbers on what they want. That number was 80% in Louisiana, who gained primacy after, but that was being challenged in the most recent legislative session. Whereas it's been set in North Dakota and Wyoming. That does not, to my knowledge, has not been challenged.
Mhm.
So it's, different states, it's kind of different issues, and that's where the local rules kind of play into it. What ultimately will end up settling out in Texas, whether you end up needing 100%, or can you get 75% or 80%? That remains to be seen. And I think that, but as Jerry pointed out, that's something that really needs to be issued as a regulation and as a body of law. And really having consistency is the key driver there.
Mhm.
Having that number unknown or having that number potentially fluctuate makes it very difficult to
It's
plan
hard to
for
make
projects.
decisions. Yeah.
From the internal sort of company, from a landman standpoint, what you really need to do is make sure that you're working closely with your technical folks and that you have a good understanding of what your plume is expected to do, what it might potentially do, what your risks and your hazards are, and sort of think that out. And that if you know your plume is going to be expanding, that depending on the jurisdiction, what your timing is on your leasing. Do you need to stay 5
Yeah.
years out of your plume, 10 years out? Because as your
Yeah.
plume expands, you're going to need a bigger and bigger footprint.
Yeah.
So it's really a matter of working with the technical folks, understanding the regulations that you have, and then making sure that you are doing the things that you would need to do as good business practices,
Yeah.
making sure that you're doing those good faith efforts to really do everything according to the rules.
Absolutely. Jerry, you just wanted to get all in that tort, so let me hear it,
Well,
man.
I mean, we've been talking about the plume with what Casey said, and that's right now we're at the intellectual stage with this, right? I mean, that not every tort carries damages with it. Somebody could breach a contract, but I actually save money. So if I sue them, there's no damages. Yeah, and it's the same here, right? I mean, we're talking about the case where you're the surface owner, you own the pore space, but it's thousands of feet down. So uh, someone causes an intrusion of carbon dioxide gas into your property, but it's not as if it's on your lawn. It's thousands of feet down. So the And we know we know from Costa de Garza that that's a physical intrusion, so it is a trespass. The question is what the damages are, and my argument is that the best measure is loss of use, because what were you going to do with that pore space? And the obvious
Yeah,
answer
six
is you were
thousand feet
going to
below.
lease it to somebody to put their carbon in, and you can't anymore because it's occupied by carbon owned and or produced by someone you did not lease to, or you didn't convey those pore space rights to, if they're
Exactly.
severable. I mean, I guess they're severable by depth or whatever. Um, so the damages are really an open question. Obviously, every time a tort's alleged in oil and gas development, it's beyond the pale that the seismic shoot knocked people out of bed and houses down and everything else. So I'm sure that it would
Yeah.
simply be a simple trespass that's alleged. I'm sure it would be you've damaged whatever oil and gas was underlying there, or
Sure.
whatever. And I mean, that's from the mineral oversight, but I would submit that it's simply a loss of use issue from the landowner
Yeah.
side, because the pore space has no other present value beyond its ability to be used for storage.
Exactly. And I think all these things that we're talking about are really living on the edges of what ifs, right? I
Yeah.
mean, this obviously these aren't the ideal situations. As landmen, our job is to put projects together and reduce risk, right? So everything that Casey's talked about has been right in line with that. You know, the good practice, best practices are to try to do this, to try to align and build your projects where your surface and feed or surface and mineral are aligned. Big ranches, big properties, secure agreements from everybody that you think the plume may expand to, right? I mean, that's best practice, and often that's what we're doing, right? When you can avoid it, but certain situations you think about, like Houston Ship Channel, you know, all the refining that happens south of Houston, Beaumont, Lake Charles area, Southwest Louisiana, Baton Rouge. You know, these are now densely populated and highly severed tracts of land geographically. And sometimes to get to these injection places where you have that perfect space, you know, big landowner that's aligned with the minerals, you got to get away from that. And that brings the pipeline component into things. Casey, you and I wanted to dive a little bit into that. What's happening in the pipeline world? I mean, obviously there's only so much CO2 pipe in the ground already, right? And those pipes are controlled by some people who they'd love to move it for you, but it's going to be expensive, right? You pay the
Right.
piper, the whole saying, right? Um, what's the latest? What's going on from the pipeline side of things? You know, currently.
Yeah, so that's definitely a key focus when you're going in and constructing one of these projects and trying to put one together. It has a massive effect on the economics of it, which, you know,
Hmm.
is going to filter all the way down to the landman level and who's on the ground. Um, as you said, a lot of the industrial areas where you're going to have your emissions are highly populated now because that's where a lot of jobs are in the region. And the land there is going to be highly fractionated and much more difficult to secure a project on. So, you know, the further away you go, the more likely you're able to pick a store where your geology, by store, I mean where you're going to put
Yeah.
your CO2, right? You're going to be able to pick the place where you think it has the best geology. You're going to be able to locate larger landowners, all right? But every mile of pipe you add on, you're adding a huge amount in cost just to build the pipe. And then you're also having to look at getting the agreements in place to actually build that pipe. You know, that putting pipelines in the ground has always been fairly difficult, but it has only gotten more difficult as time goes on, as usable space gets less,
Hmm.
land gets more fractionated, you're getting more agreements, there's more resistance to just building pipelines. You know, and there's a lot of safety and technical issues that are concerned around those. Um, So that is a really difficult thing. You also have different jurisdictions who are treating that differently. So, for instance, South Dakota, who does not have primacy, has now in order for you to get a CO2 pipeline put in the ground, you have to get 100% of your agreement signed off. There is no eminent domain for a CO2 only pipeline. And you cannot use a CO2 pipeline is not the same as a natural gas or a crude or a natural gas products pipeline. They need to be they need to be engineered different. It's still a pipeline. You're still moving material through it, but the technical specifications are very different. In Louisiana, there were bills introduced that were arguing over the percent that you would need on a per mile basis, how much you would need to have actual agreements signed up before you could start into other proceedings to where you could get your pipeline built. So,
You mean condemnation type proceedings?
yeah, or eminent domain condemnation.
Yeah.
Yeah. Different jurisdictions call it different things, but yes. So, that's another one of those things where not having a clear rule set adds just another complicating factor to it. And it is one that seems to be a very hot button issue because it is, there is going to be a lot of surface disturbance. There is going to be a lot of people that you're going to have to cross. And you need to make sure, again, that you're doing things in a proper way. So,
Yeah. Well, I think every company, every landman wants to be able to negotiate a deal in good faith with a landowner, right?
Yep.
The fact is that, you can't always do that. And do you hold up a 100-mile or a 20-mile or a 40-mile, CO2 project because you've got one holdout in the middle of your deal that you can't condemn, right? And so, I think we all as a practice want condemnation and eminent domain to be a last resort. But when you start looking at the commercial viability of even being able to build and construct this kind of project from a business standpoint, you got to have it, right? You can't be, you can't get a pipeline to to the Houston Ship Channel, running it through Houston,
Right.
right,
Right.
without going through that corridor that you can see it on every map, right? And
Yeah.
without condemnation, it's just impossible to do. So, obviously it's a big thing. We've done a couple of shorter, CO2 pipeline projects to tie in, our injection sites with our emitters, but they haven't been these big ones yet, right?
Right.
And to get into the bigger ones, where you're tying into the pre-existing lines, do you see that the industry is more focused instead of constructing a new pipeline? Are they focusing on doing kind of B2B deals with existing CO2 pipeline operators to where they can maybe build their injection sites or set their injection sites up further away from the emitter because they've got that kind of deal for that transport side of things? Is that developing? Am I asking the question clearly enough?
Yeah. So basically, I think the answer to your question is people are looking at every viable option that they can to have the different projects go off the ground. Right. So, if you've got the scale, it's a lot easier to move further away. But if you don't, then you're going to be hemmed in. There's the traditional pipeline route where if you wanted, if you just needed to add capacity, do you have it in your contracts to pull out what you have and put in a bigger pipeline? Do you have the ability to lay additional pipeline along the right of way that you already have? What contracts do you have in place that you can expand on? Now that might involve further negotiation. That generally is going to involve further negotiation with the existing parties that you have on the contract. There's also, like you said, you can explore people who already have existing pipeline, but you're going to then go into a capacity arrangement necessarily more than a building a pipeline sort of thing. And then you've got also the whole brand new pipeline on a whole brand new route sort of thing. And each project is really going to look at probably what options are viable to them. But, if you're a big company and you've already secured your access on an existing pipeline, then you have that piece sorted out, right? If you're starting a greenfield project and you're going to need to figure out how to get your emissions from your greenfield industrial site over to, where the storage person has their lease, then you're going to have to be looking at a whole brand new pipeline or laying along existing pipelines where you can expand on other contracts. So it can really run the whole gamut.
Yeah. Well, I guess the big takeaway is there's no one way to skin a cat.
No.
Right.
Oh,
Every project, it's kind of like due diligence. People ask me, how do you do due diligence? And I say, I don't know. Show me your project. Show me what you're buying and what the economic factors are and what are your circumstances and all those things. And it's interesting, guys. I really appreciate you guys coming in for an update. It's an evolving, there's so much going on, with primacy and all the other things we talked about, ownership, you name it. So it's good to just kind of circle back to this and see where we stand today. Obviously, you guys are very active and involved and well informed. So I thank you for taking the time today to share that with everybody. Really appreciate it. Jerry, how can people get in touch with you? I mean, you guys are
kmwenergylaw.com. We've got all our contact information on there. We're still in downtown Houston after 12 years, so pretty easy to find.
And Jerry's also very active, involved in the landman community. For speaking, his firm does a great job there. So thank you for your contributions there, Jerry.
Welcome.
I've learned a whole bunch of stuff. I've learned some things and forgot about all kinds of case law you've talked about over the years. And Casey, obviously you're living and breathing it, man. Thank you again for joining us as well and sharing some of your expertise and some of your knowledge.
Yeah,
We
thank you. I
appreciate it.
appreciate it. It's been great.
Yeah, maybe next year we can touch base again and get another update. Hopefully something's happened.
Sounds good.
I appreciate it, guys.
Thank you.
Enjoyed today's topic? Follow us on Spotify, Apple Podcasts, and YouTube. Learn more at dudley-land.com. See you next episode.